The theme of this first plenary is human rights, law, and ethics. Now, the preservation and the protection of human rights is at the heart of every free society, and it is an important good for social flourishing. For this purpose, laws are articulated that may sometimes limit individual actions in the interest of the common good. At the same time, ethics, including professional ethics, aspires to a higher standard of behavior that is self-driven, focusing not just on what should not be done, but rather on what is expected to be done, roles and responsibilities in our social interactions. There tends to exist a healthy tension between law and ethics, with laws moving in to fill the vacuum when ethical standards fall, when ethical norms are ignored, and when human rights are in jeopardy. To tell us more about this dynamic, we have two distinguished scholars and professionals with us today, and I'm happy to introduce you to them. And I will not delay any further and come between their talks and you. Our first speaker for the morning is Professor Laura Palazzani, full professor of philosophy of law and biolaw at Lumsa University, Rome. Professor Laura is a member of the steering committee of the Pontifical Academy for Life, Italy's delegate to the Steering Committee on Human Rights and Health in Biomedicine, Council of Europe. She is a former member of bioethics committees at the European Commission, UNESCO, and Italy. We'd like to welcome Professor Laura. Please give her a round of applause. And we look forward to her thoughts on our theme, human rights, law, and ethics. The topic of her talk will be the philosophy of law and ethics education in a changing world. Over to you, Laura.
It is my first time in India, and I'm really happy to be here. So about my topics, it's very general because, of course, we know everything is changing very rapidly because of the techno-scientific development. And generally, we say that this change is very rapid, with a very high speed, global. It affects all over the world. It's radical. It's a sort of paradigm shift. It's unpredictable, so we don't know what will happen tomorrow. And that requires a big change in ethics, a big change in law, and also in education. So I want to focus above all on education of ethics. You all know that when we talk about bioethics, about the ethics of technosciences, we always underline opportunities and challenges. So because we have a lot of opportunities coming from the techno-scientific development in medicine and beyond medicine. Think about the beginning of life issue. We can have children, even we can give children also to infertile couples. We have a very expanded increase of life expectancy. We cure a lot of illness. So we have a lot of opportunities, but at the same time, we have a lot of ethical challenges. Think about the status of the embryo, the parenthood, the end-of-life issues, the dignity of life, quality of life, cure. And now we are discussing above all the so-called emerging technologies or converging technologies. I am thinking about AI, robotics, neuroscience, neurotechnologies, genome editing, very new topics that are very complex, that needs a lot of reflection. They have a lot of uncertainties and blurring lines. So the question is, above all, which ethics do we need to educate? Because we have a lot of different ethical theories. we live in a pluralistic world. So we have utilitarians, libertarians, personal, so that's very important. And then on the other hand, we have a lot of different ideas about who is the one who needs to be respected, who has a dignity. On the other hand, we have a lot of changes in law because, as you know, I'm a philosopher of law, and so in these last 3 decades, I would say, I have been studying bioethics and biolaw, and I saw a lot of transformation. And of course, we have a lot of questions open when we have technologies. Do we need to regulate or not? Soft laws or hard laws? Which kind of laws necessary? And then we live in a very difficult situation, above all for the high speed of technology, because a lot of laws become obsolete. They become old before applying them. And then we have a lot of difference in the countries all over the world. So we have the so-called phenomenon of bioethics tourism. We go in the country where it is allowed what in our country is prohibited. So we need to learn lessons of these 3 last decades and change also our reflection on law. So we have a changing world in technology. We have a changing world and transformation in ethics and law. How can we educate now? I mean, young generations, but not only young generations, everyone. So we need to rethink education, and there is a strong accent now to the so-called ethics literacy, not only scientific, technological literacy, but also ethics literacy. We need to know something about ethics. This is transversal in every different fields, not only in the humanities, but also, above all, in biomedicine, in informatics, in neurosciences, in cognitive sciences. We need to be aware about what it is ethics and to have the main ethical categories in order to identify the challenges. If we don't know ethics, we cannot identify the challenges. So this is very important today, and I would say something about what I think it could be the ethics education transversal in all the disciplines. First of all, we need interdisciplinarity, enlarged interdisciplinarity, because we need to know something about technoscience, biomedicine, all the different fields, but on the other hand, we need to know ethics, we need to know law, human rights, and also human and social sciences. Now there is a strong accent of the importance of human and social sciences in interdisciplinarity. But what does it mean, interdisciplinarity? We need to educate, to have epistemological attitude, to keep our methodology, but to dialogue with different fields and different disciplines. And this is very important now for the new generations. The second point, I told before, we live in a pluralistic society. So everyone has maybe a different theory or different ethical principles. So the education needs to focus on the capacity to dialogue. Dialogue, it means to justify their own position, but also to listen to the position of the others. In order to dialogue, it means not to keep a compromise, but to find the shared ethical principles. And this is very important in the framework of human rights. We have a lot of documents on a regional level, on international level, that are very important in ethics and bioethics and human rights. I want to quote the UNESCO Declaration of Bioethics and Human Rights of 2005. It's a very important document just as a general framework of the human rights. Of course, we need to interpret and specify the human rights in the different settings, but in any case we have some general principles shared. That is the primacy of human beings over the sole interest of science, the principle of proportionality, of benefit risk, the principle of autonomy, of responsibility, of justice, of prudence. If you read all the documents, you see that these are very repeated principles. But education needs to be interdisciplinary, dialogical, in the framework of human rights, knowing the main documents of ethics, bioethics, and human rights. On the other hand, we need education updated, timely, because technology is changing a lot, so we need to tailor education according to the students or to people who are participating in a specific lessons or conference. And also we need education not only for students, I mean school year, high school, universities, all the different faculties, but also citizens. Now we are talking about public debate, public engagement. That's very important. The Council of Europe wrote a guide 2 years ago, very important, on public engagement, because we need to engage every citizens all over the world on the ethical issues rising from technologies. But it's not enough. We need to engage, to transfer the theoretical level to the practical level. So you know that education is not only to know, but also to do, to act, to translate our knowledge in action. But not only, we need to be, so to interiorize these principles in our action. That's why it's very important, the ethics of virtue. And I think Aristotle talked about the ethics of virtue, but we need to talk about ethics of virtue in the ethical education, because we need to educate people to have the disposal of, to act in a regular, constant way in order to interpret and apply the ethical principles. And we need also anticipation of the scenarios. I am thinking about neurosciences, neurotechnologies, AI, and sometimes the mistake, I should say, that we do when we are talking about ethics is that we arrive too late. Now we need to anticipate. There is a strong focus now on the so-called anticipatory ethics. What does it mean? It means we need to imagine the future. We need to talk about the experts of what's going to be developed in the near, or not only near, remote future, in order to introduce ethics since the design of a technology, not only after the application of the technologies. Otherwise, we are too late. We need to introduce ethics in the design. That's why it's very important to educate people who deal with technology. On the other hand, I want just to focus on another point that's very important to me. Now there is a big narrative about the education. We need to acquire, to develop skills, scientific skills, technological skills, digital skills. I would prefer to talk about capacities, personal capabilities, as Amartya Sen and Martha Nussbaum talked about. Not only skills, because when we talk about skills, we have a risk. The risk to exclude someone, to leave someone behind, because the one who has no skills cannot be engaged in dialogue or in interdisciplinary dialogue. That's why we need to have and to develop an education that's very inclusive, according to the principle of equity, of justice. That's why I think it's very important that we underline the importance in ethical education to help people to understand who is the vulnerable in the age of the technological development. And we have new vulnerabilities, not only the so-called existential vulnerabilities, so children, old people, or the different of sexes, of ethnical differences, but we have a lot of contextual vulnerabilities, depending on the single situation and context. So we need to understand who is vulnerable and help, above all, people that cannot defend themselves. And another point I want to stress is that in front of the accent on enhancement. As you know, there is a big discussion on enhancement, so the possibility to use pharmacology and technology in order to alter, augment the capacities of the healthy individual. We need to know to have smarter people, stronger people, or better people. That is the issue about enhancement that goes against the real meaning of education. Because if we take pharmaceuticals or if we use technologies in order to augment our memory, we don't even know, because it's not yet demonstrated about the safety and efficacy, but in any case, that is the idea of the so-called technological shortcut. We want to achieve some specific goals with less effort in a rapid way. And this is something that's not very good. So we need to go back. There is another word, less known but very important in the discussion, that's in opposition to enhancement, is the word achievement. We don't need to enhance our capacities, but to achieve, to flourish. I go back to the ethics of virtue. To flourish and express, even in a longer time, our personal effort and active motivation in order to develop our nature, ourselves. And that's very important. I was reading, and you know, there is the developing of a new helmet, putting on students to monitor the concentration and attention, connected with a hyphen of the parents, of the teachers, in order not to enhance the potentiality. So we don't need education like that. We need education as relationship between professors and students, and above all, as I told before, engagement. So just concluding, I want to stress the idea that education in ethics is not an option, but it's foundational. It's very important today. And above all, not only in biomedicine. I would say that after the Nuremberg Code and Declaration of Helsinki, many documents, we know that we need ethics in biomedicine, but not only biomedicine. We need ethics in cognitive sciences, in neurosciences, in informatics, in engineering, in genetics, in many different fields. Because it's very important to build the bridge, as Van Rensselaer-Potter said since 1970, so the bridge between the scientific disciplines and the humanistic disciplines. So ethical literacy, as I said at the beginning, is really very important to acquire the knowledge, the capacity to identify ethical problems and to be responsible. So we understand the impact of a technology and try to avoid, in the measure possible, all the negative aspects, identifying the challenges. And I want to conclude just mentioning one proposition. Technology is not a destiny. So, you know, there is a movement talking about technological determinism, technological fatalism, so we cannot do anything, technology is developing. No, we need education, ethical education to shape technology, since the design of a technology, in order to apply the technology in a way that is respectful of the human dignity and human rights. I'm really very surprised and happy that in the debate on AI, there is often a mention on human-centric approach. So the idea that technology is not an imperative, we need to go on technology, but we need an ethical reflection about to put the human being at the center. So what is the risk if we don't use education of ethics is the one to be unaware about the challenges and risks of technology, and the other risk is emotivism, so to have only an emotional reaction to something. And of course, all of us has emotional reaction, but we need also to rationalize, to use our critical thinking on technologies about the pros and cons, and above all, I think the risk in this age of strong and rapid technology is the one to prioritize efficiency or profit or the market, or policy. So we need to be aware about the ethical challenges, and we need to know what are the values guiding our action in the framework of human rights. Thank you very much for your attention.
Thank you very much, Dr. Laura. Thank you. Please, yes. So we heard in her most inspiring speech about the importance of ethics literacy today, saying that it is not an option anymore, and how it is an interdisciplinary understanding for dialogue and for any approaches that we may have. And this is important for human rights and the primacy of human beings over science. That ethics education should be updated. It's not only for students, but it's for the entire citizenry. And it should move from theory to practice, the importance of virtue ethics. And she spoke of anticipatory ethics rather than ethics too late. And also, finally, about ethics education being inclusive in skilling towards equity and justice. Thank you very much once again, Professor Laura. And I will hand over now to my co-chair to introduce our next speaker, and we will have the Q&A after both have spoken. Thank you.
Thank you, Dr. Olinda. Now, you know, there is a sort of a universality in ethics. And basic ethics principles are, I think, universal among humans. And yet, at the same time, over centuries, I think each civilization has evolved some nuances in ethics, in each civilization, in each culture, where some nuances differ while keeping in mind the basic principles of ethics. The second issue is that how do people acquire ethical principles? Are we born with it? Perhaps. Is the major way we get to act ethically is absorbing it from our parents, from society, nurture itself, or does it need to be taught in addition? I think we have learned over the last quite a few years, 50 years at least, that it is not sufficient just to rely on family and society, but ethics needs to be actively taught. And I think this is especially applicable to two professions. One is the medical profession, and the second is the legal profession. I think this is a personal opinion from a non-legal person, that there is a difference between a thing that is legal, I think maybe legal, but it may not be ethical. So I think this needs perhaps to be brought out to students of law, that there are differences between ethical issues and legal principles. And our next speaker, Professor Nuggehalli, is going to discuss with us or talk to us about ethics and values in Indian legal education, a second take. Professor Nigam Nuggehalli is the Registrar of the National Law School of India University, which, as you may know, is the #1 law school in the country. He was previously Dean of the School of Law at the BML Munjal University in Gurugram. He has also taught as an associate professor in the School of Policy and Governance in the Azim Premji University, during which time he also headed the university's newly founded Master of Laws program. Professor Nuggehalli holds a D.Phil from the University of Oxford Faculty of Law and an LLM in taxation from New York University, and is an alumnus of the National Law School of Bangalore himself. May I invite him to deliver the lecture.
Thank you. Thank you very much for the introduction, and to the organizers for inviting me here to this August gathering. I know that we have a limited period of time, so I'll get on straight away. And I also know that I'm the only person standing between you and lunch. So I'll start immediately. Let me actually start by saying I'm very happy that Dr. Pais talked about principles of ethics, because that's really the subject matter of what I'm going to talk about today. I want to talk about, the topic is value in ethics in legal education. I've said it's a second take. And the reason why I'm saying it's a second take is because I have 3 propositions for the audience. My first proposition is that ethical and moral values are built into the very fabric of the law. So I take issues with people who try to have a strict separation between law, ethics, and morality. I don't think that separation exists. I think the principles of ethics and morality we are talking about are built into the very foundations of the law, and I'll talk about that further. That's my first proposition. My second proposition is that legal education as it currently stands today, including at the National Law School, Bangalore, is currently not designed to teach students how to acknowledge and honor this aspect of the law. The idea that morality, ethics, and law are coexist in a very intimate fashion. And my third proposition is that legal education must encourage students to act on their genuine and firm convictions. Right? So these are the 3 propositions I'm going to defend today here, and I'm sure we'll have a discussion about that. Before I begin, I want to make a distinction between 2 kinds of values. I want to describe ethical values as values about how to lead the good life, which is sometimes taken to mean how to be happy. And by moral values, I mean what duties we owe each other. It's not about me leading a good life or being a happy person, but what do I owe other people? And roughly, we are making this distinction between ethical and moral values for the purpose of the discussion here. Now, my first proposition, as I said, is that unlike other domains of study, and unlike how traditionally people look at the law, ethical and moral values, in my opinion, are at the heart of the law. Not only is law supposed to be the medium of justice, but that the law itself cannot be understood without understanding the requirements of justice. Now, this point is clear as soon as we try to understand how to apply the law. So a legislation or a case understood in a certain way can, send people to jail or subject them to penalties or otherwise make people's lives miserable. And then we try to understand what alchemy transforms these words on a piece of paper into a legal requirement. Right? And one answer to this question, the answer I'm giving, is that words in a statute don't make sense unless we look at the values, moral and ethical, that permeate the statute. So a famous legal philosopher, Lon Fuller, memorably used the same idea in his example of a statute that makes it a misdemeanor, a penalty, to sleep in a train station. Now, a passenger gently snoring in the station was charged under this statute, while a habitual offender preparing to sleep with pillows and blankets ready for use was caught before he was actually asleep. Who was liable to be penalized under the statute? The passenger or the habitual offender? Now, the answer, if you look at the moral and ethical values impugned in the statute, such as preventing loitering in the train stations, peace and quiet in public places, means that we should absolve the passenger and punish the other person. Right? And so without looking at what the values are, it will be difficult for us to answer any legal question. Right? Traditional courses on statutory interpretation and the law in law schools, including the one I come from, do us a disfavor when they focus exclusively on maxims of interpretation and canons of statutory interpretation. Statutory interpretation, how to understand the law, cannot be confined to a straitjacket formula. In fact, in my opinion, there is a bigger problem with the traditional way of teaching law and legal interpretation. It leads to the illusion of certainty in the law. Law in law schools, and I'm sure it permeates through the general culture of the society in which we are, is considered as a code of conduct which is certain and which needs to be imparted to people. My opinion is that certainty is a problem in itself. So consider this speech in the recent movie that most of you have seen, Conclave, where the Dean of Cardinals makes the following statement. He says that there's one sin which I've come to fear above all others: certainty. Certainty is a great enemy of unity. Certainty is the deadly enemy of tolerance. Our faith is a living thing precisely because it walks hand in hand with doubt. If there were only certainty and no doubt, there would be no mystery, and therefore no need for faith. So I want to refer to another speech, again recent speech, by President Garber at the Harvard commencement address, which was also on the similar theme, right? And there he says that he's telling the students what to do in their lives after they graduate from Harvard. And he says, I implore you to hold fast to this lesson. The lesson is being open always to the ever-present possibility of personal growth. He says, I implore you to hold fast to this lesson after your degrees are conferred. The world as it is today tempts us with the lure of one might generously call as comfortable thinking, a habit of mind that readily convinces us of the merits of our own assumptions, the veracity of our own arguments, and the soundness of our own opinions, positions, and perspectives. So committed to our beliefs that we seek information that confirms them as we discredit evidence that refutes them. Though many would be loath to admit it, President Garber is saying, absolute certainty and willful ignorance are two sides of the same coin. A coin with no value but cost beyond measure. False conviction saps true potential. Focused on satisfying a deep desire to be right, we can willingly lose that which is so often gained from being wrong. Humility, empathy, generosity, insight. Squandering opportunities to expand our thinking and to change our minds in the process. So he says, President Garber says in the commencement address, my hope for you members of the class of 2025 is to stay comfortable being uncomfortable. And now this brings me to my third proposition. I've given you two propositions which I think are probably not accepted even in law schools today, which is that ethics and morality are integral to law. And that we have a long way to go before we can rid our law schools of the idea that there is absolute certainty in the law, that law brings certainty to our lives. And the third proposition is that, the one I put forward here, is that the problem with ethical and moral values is how do we go about getting some idea of what they are. In fact, Dr. Pais, when he was introducing me, referred to that already. He said, we are not sure how a person can acquire ethical and moral knowledge. And again, my answer to that is, in order to do so, we need to depend on our convictions, not lab experiments, not magic formulas, but our convictions. And by convictions, I mean genuine convictions. Why convictions? Convictions because in this domain, there's no other option, in the moral and ethical domain. Consider something as simple as courtesy. There will be widespread disagreement about this in its application. We don't have a ready-made formula that gives us an answer. And we can't make up an answer out of thin air either. We can't just depend on our unfiltered thoughts. Our thoughts can be biased, prone to error. We have to depend on our convictions, which means there's a lot of work to do before we arrive at a conviction. What is a conviction? It's an exercise in interpreting our social situation. The philosopher Ronald Dworkin has said the following in the context of interpreting the requirements of courtesy. He says, imagine the following history of an invented community. Its members follow a set of rules which they call rules of courtesy on a certain range of social occasions. They say, for example, courtesy requires that peasants take their hats off to nobility. And they urge and accept other propositions of this sort. For a time, this practice has the practice of taboo. The rules are there and they're neither questioned nor varied certainty. But then perhaps slowly all this changes. Everyone develops a complex interpretive attitude towards the rules of courtesy. An attitude that has two components. First, an assumption that the practice of courtesy does not simply exist but has value, that it serves some interest or purpose or enforces some principle, some moral or ethical principle. In short, it has some point. The second is the further assumption that the requirement of courtesy, the behavior it calls for, the judgments it calls for, are not exclusively or necessarily what they have been taken to mean, but are actually sensitive to the point of courtesy, to what the moral and ethical values it embodies, right? So that strict rules must be understood or applied or extended or modified or qualified or limited by the point of courtesy. Now, this is the lesson that I want the modern law curriculum to have. The lesson is that the issues of legality are laden with values and ethics. And this makes law students, law teachers, law practitioners, judges, all of these must be enabled to act on their genuine convictions about moral values and ethical values. The law curriculum as it stands today teaches certainty. But there's an increasing realization now that the law, because it is value laden and it deals with widespread disagreement, requires us to have convictions. Disagreement brings in its wake convictions, and that's what legal education must teach. Now, I find that the students new to the law deal with legal controversies in one of two ways. They either deny the controversy or they succumb to it. Let me explain. So when students realize that interpretation requires, some kind of legal interpretation requires judgment calls by the interpreters, and it's difficult to build a consensus on such judgments, they either claim that the existence of a controversy means a simpler solution has been missed, so they're searching for certainty, or that the controversy demonstrates there is no truth to the matter at all. In other words, there's no objectivity in the domain, in the legal domain, only subjectivity masquerading as the truth. Now, I don't have the time here to engage with both these extremes, but except to say that both are wrong-headed. Controversy does not mean a denial of truth, nor does it mean that the truth can be found in simpler, more certain terms. Now, I'm at a medical college, I'm at a conference where bioethics is being discussed. I'm sure there are people here, both doctors and medical students in the audience. Now, I hear that students in medicine also face the same dilemma when they enter medical school. They come in thinking that they'll be provided with definite means to diagnose health issues and solve them. Instead, they are told medical diagnosis involves judgment calls and are controversial even among doctors. So law students are not alone in realizing that the profession they have chosen is full of uncertainties. But we must not let the uncertainty in our domains defeat us. When we interpret the law, we will make difficult decisions, unpopular decisions, and quite often mistaken decisions. But this is the inheritance of every legal professional who wants to make any ethical or moral decisions. Legal education must embrace this challenge rather than denying it. Thank you.
Professor Nuggehalli, I think you quite clearly brought out the separation between, or at least the differences between law, ethics, and morality, and the importance of imparting this education to law students and indeed to students of all professions to include both the letter and the spirit of law. I think a lot of ethics is in the spirit of the law that we call it. The second point that struck me, of course, that we all know, but it's so important that you emphasize it, was the factor of certainty versus uncertainty. I think ethics is one area where certainty is certainly not present. Doubt, gray areas are very much present in ethics. And I think one of the functions of educating in ethics is to be able to tell the students how to handle these areas of gray areas and areas of doubt, and there is where it comes in, where you act on your convictions. So thank you so much for bringing out these issues. Education and ethics is still very much evolving in India, and I hope it continues. This institution has been giving great importance to teaching ethics right from its inception 60 years ago. Thank you so much, and I think now we have time for some questions.
I would like to ask a question to Professor Krishnaswamy, because thank you very much for your interesting discourse. You were mentioning that what students need to do is to proceed critically from their convictions. I have some problem with the term conviction, because that seems to engage an aura of certainty, that convictions are what we take to be very seriously true. In cognitive psychology, there are many studies showing that ethical judgments are often made after a first moral intuition. And I was wondering whether this term intuition might not be better to cover what you try to argue than the term conviction.
Law students must be taught to think critically, where when they arrive at some kind of a conviction on any legal issue that involves some controversy, they are not merely acting on their intuitions, but they're actually trying to act on some considered judgments that have taken those intuitions into account and have reflected on it for some time and then decided what to do. I hesitate to use the word intuitions only for that reason, which is that intuitions can be biased, can be subject to some kind of knee-jerk reactions, which we must, when we are acting in a moral, ethical fashion or making a judgment call of some sorts, must do only after some reflection. It's only for that reason that are avoided intuitions. Now, in philosophical literature, in ethical and moral literature, we have various other common terms that are used to talk about what I talked about. So, for example, John Rawls has talked about reflective equilibrium, some kind of equilibrium we achieve in our thoughts between our principles and our intuitions. And we go back and forth and we figure out what is the right thing to do after some reflection. So it's on that path that I was trying to indicate when I said that we must act on our convictions. Now, there's one thing that I want to refer to, though. When you started your question, you said you were not comfortable with the idea of conviction because it has a whiff of certainty in it, and that certainty can be false or can be mistaken or can be a misjudgment. And I'm actually getting at the same point, which is that when doubt must precede conviction, and that we should all be doubtful of our intuitions and of our initial reactions, and doubt must precede convictions, is what I was trying to get at.
Maybe I would propose another word, together with intuition, also discernment. So rational discernment. So the possibility to elaborate in a rational way our intuition. And that's very important to me in that sense, the epistemological attitude to dialogue, because we have very different ethical theories, very different possibilities to apply the same principles and interpret the same principles. So the dialogical attitude is very important today in order not to be so certain about their own, but try to justify, of course, in a rational way, what we think it's true, but also to have epistemological, dialogical attitude to talk, to listen to the others, to talk with the others in order to find something to be shareable and interpret together this gray area. That is.
And I found that the creative tension that is very well recorded or registered in both of your presentations, which is very positive and very open to the future. At the same time, is there not a vulnerability in taking a decision at the given moment? You know, when we have a lot of creative, imaginative, and discerning, kind of process in the decision making or passing a judgment about what to do and what not to do, will it not affect the action in the given situation? Of course, in a discussion like this, we can speak about theoretically, but when it is practical question, will it not affect the people who are involved and the people who are addressed?
Yeah, I think, of course, that's absolutely right. I think that the judges face this issue all the time, that they are faced with very complicated issues of law and morality, and they have limited time within which to make a decision, and that's the phenomenology of decision making in the case of judges, judicial decision making. But as you rightly put it, it's probably applicable to any practical domain. But what we are trying to we are trying to explain that phenomenon, a phenomenon in which we are asking what are the actors in that phenomenon aspiring to and what they're capable of. It could well be that some of these decisions are reached very quickly, and they're right because of the fact that the people trained in that activity are able to reach those decisions very quickly, even if they'll take a long time to justify those decisions. So that's possible in this domain. Yeah.
So if I may add something, I was thinking about, I talked about the ethics of virtue, that to me it's very important to have a sort of capacity to interpret, to specify the general principles in the contextual. Because sometimes people think that ethics is something like a code. You know every norms, you apply extrinsically, and that's all. It's not that, of course. We need to act, but also to be, to understand and to interiorize and to interpret. I think today, applying this idea above all for the new generations, but not only in this technology so fast developing, I think one way is really very important to educate, to work together. I make you an example. As soon as I understood that it was very important to develop an ethics of artificial intelligence, I worked a lot with engineering, with computer scientists, data scientists, because it's very important to exchange views. They need to know something about ethics. I need to know, of course, a lot about informatics, but really educate to work together is one way to develop in a concrete way the interdisciplinarity and dialogical attitude.
We're seeing instances in federal and state law where artificial intelligence is actually building caseload arguments on caseloads that are much quicker and perhaps more in depth than what the attorneys are able to do. How do we, as this group, prevent artificial intelligence from taking that wonderful aspect of creating dialogue and bringing virtue ethics into decision making? I'd just be curious what you both think about that.
So I believe strongly on the education of judges. Because in the Council of Europe they developed a course that's now very important on ethics and human rights in technologies to judges, because I am talking about, above all, the European world, but sometimes the parliament, the legislation is very difficult when you deal with bioethical issues, with a technological, very fast development. So the legislator sometimes is delaying and postponing a legislation so that the conflict is there, and so we need the intervention of a judge. So the case law is much more developed than the legislation sometimes in bioethics. This is the lessons we learned from bioethics, and so we will try to do something different now. So I think also legislators need education in ethics, and judges need education in ethics so that to reflect. And now maybe you saw in the literature there's a new word that is governance. So the idea that law needs to develop a new way to rule, to give rules, today because of the fast development. And so we need a sort of discipline, a framework that's more adaptive, that's capable to adapt to the new technological issue, more flexible. So it should be hard, so with prohibition of something that's very, very highest risk, but at the same time to develop the way to manage the middle and low risk. This is the example of a regulation in Europe. We had last year a regulation on AI in Europe, the first regulation in the world that's developed on this different level of risks, giving with the annexes all the technical instruments for the application of different cases. Because, of course, the problem is adaptation of a regulation in front of the advancement, very rapid advancement of technology. Because what you are writing now may be different next week. So that's the idea of the adaptation. So to give the categories, the instruments to govern, that's the idea of governance, adaptive, flexible governance of the new technologies. This is the new idea.
Yeah, well, to answer your question specifically on the art of writing judgments, I'm still trying to get my head around that. I mean, a typical judgment has various parts. Some of the very tedious parts, like which lawyer said what, and what are the facts of the case, and what's the applicable law, what are the applicable regulations, and you know those parts. I think AI would be very helpful in. I mean, somebody has to lay it out, so the AI can do it. But I'm still trying to get my head around how every legal judgment will have a moral decision at the end, right, about what the law means. And I'm not sure how an AI will be able to do that. An AI will be able to say something, but whether that something is, I mean, something has to be reviewed by the judge, because the cutting edge of a judicial decision is some demonstration of some conviction on a moral or ethical question. So, you know, if I say, for example, that there are no motor vehicles in the park, there's no Motor Vehicles in the Park Act because we don't want to have any motor vehicles in the park. And then we have an electronic toy machine that comes into the park and goes before the judge. I mean, I don't see how an AI is going to give an answer to this question. The AI is going to be able to tell me all the applicable laws and regulations, but in the end, we need somebody to make a call on this. Is this rule about no motor vehicles in the Act because we need peace and quiet in the park? Or is it because we need this rule because we need to have security in the park? We don't need people being hurt. There has to be some moral or value that somebody has to take a look at. And AI probably can generate an answer, but an answer has to be reviewed and validated by a human person. I mean, otherwise I don't see how this can work.
Thank you. I think you've come to the end of the session. May I just take the chairman's prerogative to make a last comment? Perhaps in this forum of education and ethics, we should have a session on how to educate artificial intelligence on ethical principles. Nowadays, you can teach artificial intelligence anything, large language models, so perhaps we can build in a system by which not only law information, but also the various possibilities, ethical and moral, also come out through the options you receive. Thank you so much. Thank you, the audience, for taking part in this session. Thank you.
We have mementos to hand over to our distinguished speakers. I request the two chairs to do the needful. So Olinda is handing over to Dr. Laura, Professor Laura. That's an Indian traditional shawl, which has got the emblem of St. John's. I request Dr. Prem Pais to hand over the shawl and memento to Professor Nuggehalli. Big hand to both of them. I request Dr. Rani to hand over a memento to both our chairs. Insights and for chairing the session so well. Dr. Olinda, thank you for handling the session and for coordinating with our speakers. Thank you so much.